Welcome to Essential Estate Experts, the estate planning podcast and ultimate resource for understanding estate planning and elder law, brought to you by Screenfire Media. Let's get started.
Well, hey there, folks. Chuck here, and welcome to Essential Estate Experts, the show where we break down the myths and misconceptions that go with estate planning. Today, I'm really excited because we are joined today by Dinesh Chawla of Chawla Legal Group. He's based out of Michigan. Dinesh, how you doing today?
Doing very well. How are you, Chuck?
I'm doing fantastic. Thank you. And I am not going to be breaking down the essentials of estate planning in Michigan alone. I am joined by my co-host, Mr. Mark Zazada. Mark, how you doing today?
I am great, Chuck.
Okay, but before we dive in with Dinesh, I do need to make a quick note. We ask that you please be aware that the information provided on Essential Estate Experts is for entertainment and informational purposes only. Listening to this podcast does not establish an attorney-client relationship. Always consult with a qualified lawyer before making any decisions related to legal matters, and do not take legal advice from a podcast, okay? All right, with that in mind, let's get into it. So, Dinesh, we're going to start with the question that we ask all our guests. How the heck did you end up in estate planning?
My dad came to me and said that he needed his estate plan looked at. And when I took a look at it, I was no expert at the time, but I remembered back in law school certain things. And I realized that this estate plan was not going to do my parents justice. And quite frankly, it would have harmed me and my sister's beneficiary. There was a lot of stuff that would have been left on the table for probate and other things. I fell in love with what we could do for families. So just through my own parents' experience, I kind of saw what the ins and outs were. And the estate planning niche, I instantly found an interest and a passion just because it mixes so many different things together, from real property all the way up to probate. There's a lot of asset protection work for high net worth individuals. There's tax implications. It's a lot of fun stuff all wrapped into one. So it's something new every day. Everybody has their own experience. So in my mind, it's one of the most creative fields of law, because essentially, as long as we're not doing anything in our plans that are illegal or against public policy, if my clients want to name their trust a certain name, as long as it's not breaking any copyright laws, we can have fun and do that. If they want to make crazy rules, like I want to be dipped in a vat of copper and turned into a statue after I die, and if I'm not on my son's front lawn at all times, then he loses everything. That's a legal thing. Like, you can actually do crazy stuff like that. It leads to a ton of creativity, and it is actually, the topics are awful, death and disability, but the process can be super fun.
Well, I'm hoping that's not a real example about the dipped in copper, but if it is, we'll get to it later. Yeah.
I always give that as an example to my clients, Mark, as an extreme. And when they say, "Who thought up of that?" I say, "I did. That's what I want my plan to be. I really want that. I'm just not there financially yet." Okay.
Okay. You mentioned elder law, and can you explain what that is? Because I think people
Sure.
don't really understand. What's the difference between elder law and estate planning?
So estate planning is something that we do before the proverbial stuff hits the fan. Okay. It's a way to make sure that we stay in control. We take the government rules, the court rules, and the nursing home rules out of it. Okay. If somebody hasn't made that plan in time, if we're in a crisis situation where mom or dad just had a stroke and they go into the nursing home, we now have to figure out, how are we paying for that nursing home? Or if somebody's currently residing in a nursing home and they're down to their last $50,000, it's how do we protect that last $50,000? So when it comes to who's paying for the nursing home, we have a few choices. We can private pay. We can get long-term care insurance. There are Veterans Affairs benefits. Those are all capped. Medicaid is actually a very robust program that will pay for nursing home stays. You just have to be down to $2,000 worth of assets, but those are countable assets. And there's a ton of nuances in the law that allow us to protect and preserve a lot of our hard-earned money and not have to give it up to the nursing home, but still qualify for Medicaid. So we have clients in nursing homes that cost between $10,000 and $13,000 a month. Our clients are paying what their income is to the nursing home, but they've got certain amounts of money in an asset protection trust, and Medicaid is picking up what their assets normally would. So they can still have a proper succession plan. It's just with a lot less money because we can only protect so much.
And I can see how I might need a lawyer to help figure that out and fight some of those battles.
Right.
I'm really
Yeah.
curious, Dinesh. Like you mentioned that you had looked at your parents' estate plan essentially and found a lot of problems with it. What was it that they had done before to generate that plan?
They went to an attorney that was recommended to them by their very trusted financial advisor. And that attorney, quite frankly, didn't do 100% of the job. And I'll say this about a lot of estate planning attorneys. It's kind of our business model that I don't like. So I strayed away from it. The business model is to give people an estate plan, but then give them about 15 pages of funding instructions on how to get things into your trust. The great majority of clients don't fund their trusts, meaning they've got a trust that they paid anywhere from $2,000 to $5,000 for. That's just a bunch of words on paper because they didn't put stuff in it, because they didn't follow those 15 pages worth of instructions, which in my mind is very important legal work. So for us to not provide that follow-up service is a disservice on our part as attorney. Do we offer that to our clients? We do, but at a discounted rate from our normal. We actually do quarterback the funding and make sure that all those loops are closed, because that is exactly what would have destroyed my parents' plan, is that it wasn't properly funded. They didn't have their assets in the trust because they really weren't instructed to do so. And the limited instructions they had didn't define how. It just said to do it. Like, get your stuff to the bank. That's it.
Let me just jump in. And for members of our audience who might not know what a trust is exactly, could I just characterize it as a kind of legal box that you put assets into, and that makes it really easy to pass them on to the next generation, whether it's your spouse or your children. And if you don't put the stuff in the box, the whole thing doesn't work. Is that a good way to put it?
See, it's actually, it's funny because we actually haven't talked about this, but the box is actually the visual that I use in our workshops to explain a trust. We have different types of trust. There are many different types of trust, but the three main things I show are a box with no top. That's our common revocable living trust that we put assets in to avoid probate. Then we have a box with a kind of a semi-open flap on top, and that's our asset protection trust, where we're not worried about estate taxes because they're not that high in terms of their asset count, but they've got enough assets for us to worry about them losing in, let's say, a bankruptcy or a divorce or any other type of judgment. So a slip and fall on a property, whatever it may be, we don't want those things touched. So it's kind of like a hybrid between your revocable living trust and your irrevocable, completely closed off box for tax purposes, that this is now basically, we've given everything to the trust. It's got its own EIN. It's not taxed against your 1040s. So like I said, there's a ton of different trusts. It can get very complex, but you simplified it perfectly. The most common use of a trust is to put things in that box to avoid probate.
So Dinesh, I think a lot of people think trusts are for rich people. I'm hearing that it's not always just for rich people.
And again, it's almost like you've watched one of my workshops, which I don't think you have. I've never seen you attend one, but that's actually one of the things that we start off with, is that estate planning, not just trusts, but estate planning isn't about assets. It's about control. And anybody who tries to refute that, I'll bring this up. The two very foundational documents in an estate plan that, in my opinion, everybody over the age of 18 needs are your sets of powers of attorney, a healthcare power of attorney and a general power of attorney to handle legal and financial decisions. But as soon as you turn 18, you're your own person within the eyes of the state of Michigan. Within the law of the state of Michigan, you are your own person. If anything goes wrong with you, if you're in a coma or you can't speak for yourself, who's there to speak for you? It's not mom and dad, even if you're on their insurance, absent a power of attorney. Or the flip side is they can get that control back, but they have to go through a guardianship or conservatorship. So again, it's about control. If I have a power of attorney in place saying Mark is going to be my agent for legal and financial decisions and Chuck is going to be my agent for medical decisions, the control is still mine when I go into that coma. Okay. So that has nothing to do with assets. Yes, it's giving one of the two of you the ability to manage my assets for me, but the underlying theme there is who's in control when I can't. So that's what it boils down to. And then the trust, you can have $1, put it in a trust and give your specific rules on how that dollar is distributed upon incapacitation or death. So again, control.
You mentioned some of the aspects of Michigan. If I'm moving to Michigan, what do I need to know? What's different about that state?
So and it's not so much different about the state of Michigan as unique to the state of Michigan, but Michigan is one of the states that does accept what's called a ladybird deed. The simplest way I can explain this is the ladybird deed essentially gives a property owner the ability to put a beneficiary on that property, whether it's a resident or a rental property, doesn't matter. So if I have a house in Michigan that's owned by Dinesh Chawla, I can deed it to myself as a life estate, meaning I can own it during my lifetime. And if I die and I haven't previously given it away, then this person, usually a child, gets the house. Huh. So it automatically springs the house from your estate to that other person, so it doesn't get counted as a probate asset. So what that does is it makes our wills in Michigan actually a very powerful tool, because if we couple a will with a ladybird deed and it's appropriate, then we don't need a trust to avoid probate in all cases. If our assets are structured that everything can have a beneficiary designation on it, then we can get away with a will plan and a ladybird deed coupled together, and beneficiary designations on our bank, our life insurance, our 401ks, IRAs, all those things. And we've just avoided probate with a very simple suite of tools for estate planning: your powers of attorney, your ladybird deed, and your will. Now, herein lies the problem. With that, it means we have to focus additional attention on the beneficiary and their status. Because if I am deeding a house to a beneficiary who has special needs or a disability, I could very well raise their asset limits and deed them right off of their benefits that they're getting, their government assistance. If they're on student loans at the time, going through college, that's an asset-based program. If I now gift them $50,000 of life insurance because I died while they're going through college, then that $50,000 has to be spent down before they can get back on their student. So there are nuances there that make it imperative for Michigan attorneys to not just look at the client in that first generation of, if my client and their spouse in traditional estate planning, or their partner or whoever it may be, if they pass away, we want to follow their intentions, but we also have to pay specific attention to the beneficiaries, because I say this very candidly in my workshops. The thing that kills estate plans most in Michigan are the idiot beneficiaries. Something goes wrong with the beneficiaries. They make a bad choice, or they themselves, not bad people, but they have issues in life or creditors. Maybe one's a serial entrepreneur who's going through a bunch of bankruptcies because business failures happen. People don't always discuss that with their parents. So now if I ladybird deed a house to my two kids and one of them's going through a bankruptcy unbeknownst to me, I've now made my kids, in effect, landlords with the bankruptcy court, or partners in property with the bankruptcy court. So those are things, that's why I say in Michigan, we absolutely have to pay attention to the next level of people who are in that plan. So communication with our agents, our successor trustees, our beneficiaries, once we get that plan signed. So they all have for the agents and successor trustees, a very specific idea, but for the beneficiaries, a very broad idea of what's happening with the plan so it can be honored when it needs to be honored.
Well, I'm hearing a lot in there that's really crucial. And one thing is for people who are creating wills and trusts and these special circumstances to really think through the consequences that are actually going to happen to their beneficiaries, and to think that through with an attorney who understands how this kind of thing works. Because it's all too easy to just write, I give everything to Johnny, without understanding what's going to happen to Johnny when that occurs, or how Johnny's going to deal with it, right?
The reason I love planning is because I get to nip these things in the bud. I get to identify them. And here's one of my favorite stories to tell about the Ladybird deed, because it's very, very useful tool, but it's also a very dangerous tool if used incorrect. So I got a call one time. It was from a CPA, and I know it was a CPA because he told me 5 times in about the first 15 seconds of a conversation that he was a CPA. And he said his brother was falling into a dementia state, and they wanted to put a Ladybird deed around the house. So it would go to his niece and nephew, right? The brother's son and daughter. So I said, that's great. He said he had everything drafted. They just needed me to review it, and he wanted me to do that for free. So, he was trying to get some free work, which is fine. I get that. But when I asked him what was going on with the kids, he said, what does that matter? And I said, well, just tell me what's going on with the kids. And he said, well, my nephew lives in Florida, and my niece lives with my brother in Michigan. She has her own house that's like about a mile away though, but she stays most of the time with him. I'm like, okay, what about your nephew in Florida? He's like, he's got his own house. He does his own thing. I said, okay. I'm like, are either of them married? He said, nope. I said, okay, so we don't have to worry about divorce. I said, do either of them have special needs or disability? He said, they're both collecting disability.
Wow.
I'm like, so now you, Mr. CPA, who's supposed to understand tax consequences, which you may, but now if your brother dies, this house is going to go, all $250,000 of that value is going to go in the asset count for your nephew in Florida and your daughter in Michigan as a secondary resident, which means they're getting knocked right off their disability pay.
Wow.
People don't think about these things, and that's my job to catch. So yeah, they're nuanced.
They don't think about these things. And in my experience, speaking mostly to attorneys, I admit, CPAs don't think about these things nearly often enough. CPAs often, it's so often after the fact, dealing with issues rather than planning forward. And often I think that is the job of an attorney, to think forward on tax issues like this.
Yes. It's our job to understand, like, I'll be the first to admit, I don't understand all of the ins and outs of the tax rules and the credits that can be taken and this and that. That's a CPA's job, and I respect that lane.
Sure.
I don't, however, think a CPA should be jumping into the legal lane, just like I wouldn't jump into the account. So for a CPA to be diagnosing a situation with a Ladybird deed, to me, is inappropriate. It would be like me diagnosing a situation with saying, yeah, don't do this because of the tax implication. Like, I can't say whether something's more efficient tax-wise. I can tell you whether something is legal to do tax-wise, but from a tax efficiency standpoint, that's more the CPA's job. And I would defer to that CPA to understand that better than me. So I get that in my example, the CPA was deferring to the Ladybird deed advice to me, but at the same time, he was kind of pushing and proud of the fact that he created this Ladybird deed when it was an unnecessary evil, like it would have ruined the plan.
Okay. You know what? The other thing I heard in what you said earlier is that you don't always necessarily need a trust in Michigan. I'm in California, and the attorneys here It's always, you have to have a living trust. But I'll tell you, I'm actually dealing, I'm a trustee right now for my mother's estate. And it would have actually been a lot simpler. She only had bank accounts. It would have actually been a lot simpler if there wasn't a trust at this moment. So it isn't necessarily always true.
No, it's a case by case situation, and that's why you hear of these quote unquote trust mills, attorneys who you sit down across the aisle from, and you say, "I need an estate plan," and they're like, "You need a trust." Or we get people coming in all the time saying, "I need a will and a trust," and I say, not in a condescending way, but it's one of my favorite questions: is why? And more often than not, the response is, well, my parents or my aunt and uncle or my neighbor have an estate plan and they've got a will and a trust. And then my next series of questions are, okay, tell me what your aunt and uncle have. Oh, they've got 3 houses, some boats, jet skis, this and that. All right, that's a lot to control from the grave and incapacity. What do you have? I've got an apartment and a cat. Well, guess what? You don't have that much to control. So I'm not going to put somebody in a plan that they don't need. If somebody comes to me and says, I need to get from point A to point B, they don't need a Cadillac or a Lincoln to get there. They can get there on a skateboard or a Pinto. That's fine. So we figure that out. Each case is an individual. I look at each person, even if it's a married couple, they don't agree on everything in their plans. So there are parts of their plans that are very individualistic and very customized. And for people to go to a trust mill or one of the online sites where you're skipping out on legal counseling and doing it yourself, there's a lot that people don't know that can harm them. And if they do it themselves and they print things offline, then they can't think that that is the legal gospel and just sign off on it. Without an attorney intervention, 9 times out of 10, you're going to see some things blow up in your face in this field of law.
You may not be there to see them blow up, but they still blow up.
Yeah, exactly.
Yeah, I'm curious about that because I have a connected family that there's a lot of siblings and there's a lot of drama, and while the siblings themselves don't necessarily have a lot of assets, the patriarch of the family does, and so I'm hearing all this. I'm hearing all of these concerns about, the issues that could face a successor if there's suddenly a bunch of assets dropped on them and they're not prepared for them, or they're not, if they're on disability and all of a sudden they lose their disability because of this. So as a potential successor, would they need their own attorney? Is there action that you can take before the patriarch passes? And if it does happen and they do pass and you're looking at this going, oh no, I'm screwed. I've got to pay all these taxes, or I've got, all of a sudden the bankruptcy court is taking over the family house. What do I do?
Okay, so the favorite legal answer right off the bat is it depends. And we start all of our answers with it depends and then move to option. Okay. So again, it depends. If it is a revocable living trust or a will, and one of my beneficiaries gets a hold of it while I'm living and they don't like what they see and they hire an attorney to come at me to change that, they have no standing. They can't do that because while they're entitled to things based off what that document says, I also have the ability to revoke and change those documents anytime I want during my lifetime. So they have no legal rights to any of that stuff until I die. And if it's a probate case, till the judge stamps the letters of authority for that personal representative and admits the will. Then they have entitlement and they can get a lawyer and protect their rights. If in that will or in that plan, in Michigan, this is legal, you can do this. If I've disinherited one of the two of you, you basically have no recourse. If I've consciously said in my testamentary documents that I want Chuck Ellis to have nothing to do with my estate, no way, shape, or form, I can do that to my own spouse if I want to in Michigan.
Wow.
So yeah, it always depends. Like I said, estate planning in Michigan is one of the most creative fields of law I can think of. It allows us to do a lot of different things. Again, it might not sound like the most wholesome of things, but we are allowed to do a lot of playing in the gray in Michigan because, again, if it's not against the law or against public policy, it's pretty much fair game in Michigan.
Let me just explain a couple little things in there, again, for listeners who may not be familiar with all these terms. Probate is the court process, which is not always necessary after a death, but is necessary if there is not a trust or a clear designation of beneficiaries in certain assets. You want to amend that, Dinesh, but explain a little bit what probate is and a little bit of the experience of probate in Michigan.
So in Michigan, we have to go through probate if there's a minor child involved, because the probate court is the only one who can transfer a guardianship of a minor child. If there's a conservatorship or guardianship involved, the probate court has jurisdiction. Then we come to what the most common form of probate matter is, the decedent's estate. So when somebody dies and their estate has to go. So here's what the probate process is in Michigan. It's a minimum of 4 months, because when we give notice to creditors that we've opened a probate, they have 4 months to respond. Otherwise, they're barred from responding and laying claim to the estate if they don't do it in that 4-month period. The other thing with probate in Michigan is it's only going to be required, like I said, if there's a minor child involved, or if the person who passed away died with any property in their name alone. Okay. So if I have a deed to a house and it's in my name alone, then that house is a probate property. If I have a deed to the house that is a joint property, then depending on how that joint property is written in the deed, because Michigan is very specific about its deed work, 50% either goes to my estate, or if the deed says joint with rights of survivorship, then that means if one of the joint partners in that property passes away, the other one gets it free and clear when they die. Okay. So those are very, very common in Michigan, and there are common pitfalls to both of them. But if I die with anything in my name without a beneficiary designation, anything like that. So if I die with life insurance with no beneficiary on it, a bank account with no beneficiary on it, an IRA, a 401k with no beneficiary on it, those properties are probate properties. If those things are properly titled in the name of the trust while I'm living, or the beneficiary of those properties are the trust upon my death, then we've now avoided probate. Currently in the county that I sit in, we're averaging about 18 months for a probate, which isn't too bad. Again, not too bad. The last 3 that I've done have been very, very simple probates. It's only involving only children, and these children were living out of state. So like we had one person whose mom passed away in my home county, and somebody whose dad passed away in my home county. The guy whose dad passed away lives in Florida. The guy whose mom passed away lives in Colorado. So we handled their cases virtually from Michigan, both the same county. We filed both on the same day. One got processed in 20 minutes, and the other one, because I came back after the lunch hour, they were already on a 3-week delay. So, and they were filed at the same time. Well, it's amazing how fast courts change. This is what I was going to get to that I forgot, Mark. You mentioned something about political and the laws changing. Yeah. The State Bar of Michigan says on their website in the estate planning section that you should get your estate plan reviewed every 3 to 6 years. Now that policy is there, that recommendation's there, because every 3 to 6 years in the state of Michigan, there's either a state Senate and congressional election or governor election. So every 3 to 6 years, there's a chance that policies and laws are going to change. So they suggest you change your estate plan according to that. I think your life can change every year. So we do annual check-in. But that was a very pertinent statement that you made, because it's true. Laws change all the time, especially every 3 to 6 years.
Do you have any examples of what happens when people don't update their estate plans?
Actually. So we had one lady who had an unfunded plan in Florida. I'm working with her kids in Michigan, because like I said, she drafted her plan. It had a trust. They didn't fund it. And now there's almost $1.5 million worth of assets that are all going into Florida probate system, because this is something that could have gotten tracked on an annual basis. Have you funded your trust yet? No. Why not? Here are the instructions. The next year, have you funded your trust yet? No. Why not? Here are the instructions. Or, hey, you haven't funded your trust yet? Maybe it's worth it to you, but for an extra X amount of dollars, we'll take the lead on that as the attorney who should be doing it in the first place. So there's lots of different ways to skin this cat, but it ultimately comes down to it gets caught in annual reviews.
Right.
All of that. So do I have a good example of it blowing up in our face? Not yet. Thankfully, it hasn't blown up in any of my clients' faces. So personal anecdotes about that, don't have them yet. Hopefully we never do, because like I said, we do perform those annual maintenance.
Mm-hmm. We know that getting a will and trusts and all these things, the initial investment is for some people could be considered large. So you're looking at a couple $1,000s minimum to get all this put together. And when you're doing an annual review, what's kind of the expected maintenance on that? Like how many hours are expected to be put into something like that?
So the average for us, it's an hour-long meeting. Client sits down. Because we do in-house funding, we have what we call our probate avoidance or our funding profile, depending on if they have a will or a trust plan. But it's the same tool. It shows all of their assets. So if it's a bank account, it'll say Chase Bank. It'll say Dinesh Chawla owns it individually, not jointly. It's a checking account. Last four digits are 4321. We have a spot for value, but I often don't fill it in because I care more about the control. But then it'll say, who are the beneficiaries on the account, primary and the contingent. So we can track that on an annual basis. So our meetings are about an hour. We say, have any of your assets changed? Have any of the beneficiaries changed? No? Great. We move on to the powers of attorney. Your agents, any of your successor agents, are they still capable of making decisions for you? Because what I don't want to see, because I've seen this blow up in other people's plans, is that as we age, our agents also age. And some of them might become incapacitated before we do, and we've fallen out of touch with them. So, when the proverbial stuff hits the fan for us, we want to make sure that our agents are able to handle this. So it looks like us reviewing the probate avoidance plan, the powers of attorney, and then we want to make sure that your personal representatives and your beneficiaries of whether it's the trust or the trustees the will for the personal representative and the beneficiaries, or the trustees of the trust and its beneficiaries. We want to, again, make sure on an annual basis that things are still the way they were a year ago. If all is good, then we make them sign an attestation or affirmation that the plan is still in working order according to their intentions. And now nobody can come in and say, somebody was taking advantage of mom and dad in their old age, so they did this, that, or the other thing. We have an annual attestation saying, no, this is what we want. Nothing has changed. So it gives us that opportunity. And that's our paid membership program. So clients actually pay for that. They also get pretty much all of their phone calls to us are free. I don't really charge them that much after they've paid for follow-up services, but it's all legal services following up to make sure that their plan is going to be what it needs to be when it needs to be. Everybody else gets a complimentary email every year saying, hey, if any of these 15 things have changed, it's time to kick the tires and get on Dinesh's calendar, and we need to review your plan. And you're going to pay for it because you're not part of the annual maintenance program. So those are the types of things that we do to actually maintain a relationship with our clients and understand how their lives are going. Because the last thing I want to happen is for somebody to pass away and they've outlived the needs in their plan. And now they've got this crappy plan sitting there that didn't work, and it's got my name all over it.
Yeah, the number of people who write a plan and stick them in a drawer and forget about them for 25 years is pretty high. right? And
Yep.
the chance that is still going to make sense with all the births and deaths and incapacities that have occurred in between are pretty low. Okay, I'll just give a little personal note here. We may cut this, but I'm working through this right now with multiple banks, and what's really stunning is how every institution deals with this differently. Every bank
Completely.
has different policies, has different forms, has to see different documents. You have to talk to people, multiple people who often don't understand how to deal with the trusts. And the people who are knowledgeable at the banks, they complain how every trust is different. So this is on the lawyers here. They're all different. How they handle things, how they're written, where the stuff is located in the trust, every it's not simple on either end of the
Right.
scale. So that's a challenge to the whole industry, I think.
So, Dinesh, we've talked, every scenario is different. There's a lot of it depends when it comes to things, but I'm sure there are a lot of common things that people make mistakes all the time. What are some of the things that make you beat your head against your desk and go, "Oh, it's this again," when somebody comes through and they're ill prepared for what they need you to do?
It's just getting over the common misconception that you need a ton of stuff to do an estate plan. The question, when should I start, is the biggest. I'm pounding my head against the table because I have educational programs. I've got workshops. I've got YouTube videos, shorts, social media posts all over the place saying, as soon as you turn 18, get powers of attorney in place. That's my rule of thumb. The only two rules of thumb I have in estate planning, period, is if you're 18, you should have powers of attorney in place. And if you have a child, you should have a will naming who their guardians will be should both of their biological parents pass away. Those are my two rules of thumb. Minor child, have to have a will. Turned 18, you should have a power of attorney in place. Two, actually, healthcare and your general.
So, looking at your site over at Chawla Legal Group, you're really big on digital and virtual services. So, how does Chawla Legal Group handle digital assets in estate planning? Like, how should people prepare their digital records for something like this?
Again, it depends on what type of digital asset we're talking about. So, if we're talking about like a Google or a Yahoo account, you can actually put like a password beneficiary or like an agent on your account. So if anything happens, they can actually call into Yahoo or Google or anything like that and have clearance to change your password and all that, so you can manage their account, that account. Now with an actual digital currency like cryptocurrency, a trust can own a digital wallet or a crypto wallet. So you can open up these accounts on Coinbase or whatever currency exchange you're using in the name of a trust or any other type of entity. So as long as somebody, a trustee or successor trustee, has all of the passcodes to that, you're good to go. So again, it's just like traditional estate planning. We're just tweaking it for digital assets. So how do we get into our digital assets? It's oftentimes with passwords and user IDs, right? So as long as we know where those passwords and user IDs are and we're giving them to trusted individuals, then we're good to go. It's people try and complicate this stuff too much. It's really not that complicated.
Dinesh, we're getting close to the end. Do you have a couple key pieces of advice that you would like to leave?
Yes. So I'm just going to reiterate the key rules of thumb that I have. And that's if you're 18, get a set of powers of attorney in place. If you have a child, get a will in place so you know who the guardian of your minor child will be should you pass away. And if you have a trust, fund it. Having an unfunded trust, a lawyer giving somebody a trust and not doing funding is like a car dealer giving you a car without your key fob, but instructions on how to start it. It doesn't make sense to me. Your vehicle's not going to go anywhere.
That's great advice. And let me just add my last piece of advice is estate planning is not a do-it-yourself project. Get a lawyer, get an in-state lawyer who understands estate planning very specifically. And if you're in Michigan, Dinesh, how do people get in touch with you?
So if you're in Michigan, they can email at dinesh@chawlalegal.com. They can call our office line, which is 586-273-7157. They can go to our website, www.chawlalegal.com. We are at Chawla Legal on YouTube, at Chawla Legal on Facebook, at Chawla Legal on LinkedIn. We have a ton of different facets to do. If people go to attorna.legal/Chawla Legal, that is our portal to a kind of you do it, we review it, wills and powers of attorney website. So there are some do-it-yourself websites that don't take the attorney out of it, attorna.legal being one of them and the one that we actually subscribe to.
Oh, that's interesting. And if you're wondering, folks, Chawla is Chawla. Chawla Legal in Michigan.
Well, that was fantastic. Dinesh, again, thank you so much and really appreciate that. I highly recommend you check out Dinesh's site. That has a lot of really great resources and information on it. We'll be linking to his site in the show notes below, so be sure to check that out. And while you're down there, if you're watching this on YouTube, be sure to like, subscribe, hit the bell so you'll know when the next episode of Essential Estate Experts comes out. And if you're listening on your favorite podcast app, we would really appreciate it if you go and give us 5 stars. That really helps people find us. And if the information was useful, share it with your friends and family. I'm sure you've got people in your family that are getting up there, or maybe you're getting up there and you found some of this information useful, and sharing this around can really save some people a lot of pain and heartache later. But as always, we want to thank you for joining us today. Until next time, we'll see you later. Take care.
Thanks for listening to Essential Estate Experts, presented by Screenfire Media. Please remember to like, subscribe, ring the bell on YouTube, and rate us 5 stars on your favorite podcast app. It really helps. For more information, please visit screenfiremedia.com. Essential Estate Experts is copyright 2023 Screenfire Media, all rights reserved.